Be ready. Start. This writ appeal has been filed against the judgment dated 18/6/2015 in WPC number 18893 of 2014 filed by the respondents herein, which has been disposed of by the learned single judge. Brief facts necessary to be noted for deciding this writ appeal are: the appellants initiated proceedings under Section 4(1) of the Land Acquisition Act 1894 in bracket hereinafter referred to as the 1894 Act for acquisition of land for construction of CC Road on 22/12/2010. Urgency clause under Section 15(4) of the Act was also invoked. The land acquisition collector made payment of 80% of the estimated compensation to the petitioners. The petitioners received the amount in March-February 2012. After making payment of 80% of the estimated compensation, possession was taken in the month of March 2012. Declaration under Section 6 was issued on 31/1/2012. Notices under Section 9 of the Land Acquisition Act were issued. Construction of the road was completed in September 2012 itself. However, no award under Section 11 could be declared by the land acquisition officer. In the meantime, the right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013 in bracket hereinafter referred to as the 2013 Act was enforced with effect from 1/1/2014. 20% of the balance compensation was also not paid to the petitioners. The petitioners filed the present petition praying for the following reliefs: 1. To call for records relating to Exhibit P1 to P6 and issue a writ of mandamus or other appropriate writ or direction directing the second respondent to pay the balance 20% amount to as per Exhibit P1 to the petitioners within a period of 1 month and pass an award on their acquired properties as per the provisions of the new Land Acquisition Act 2013 as expeditiously as possible within a time frame fixed by this honorable court. To issue appropriate writ or direction directing the second respondent to the restore possession of the acquired properties to the petitioner. 2. Counter affidavit was filed by the respondents in the writ petition, wherein it was stated that 20% balance amount of compensation has not so far been paid to the parties due to unavoidable administrative reasons, which shall be released as early as possible. It was pleaded in the counter affidavit that 80% of the compensation has already been paid and the only entitlement is to get 20% of the balance compensation. Section 24 is the silent on the emergency provision of acquisition of land under the old Act. Implementation of the completed projects under the new Act is impracticable and against the principle of law. The learned single judge held that the award having not been passed under Section 11 of Act 1894 by virtue of Section 24 of the Act 2013, the award is to be passed under the 2013 Act. The learned single judge, however, held that the amount of 20% of the compensation will be dispersed and award be passed under the new Act. The Union Territory of Lakshadweep and the Land Acquisition Collector have come up in this appeal against the judgment of the learned single judge. Para. Sri S. Radhakrishnan, Learned Counsel appearing for the appellant in the support of the appeal, contended that the under section 117(3)(a) of the Act 1894, 80% of the compensation having already been paid, the only entitlement of tenure holder is to receive 20% of the balance compensation. It is contended that the intention of the legislature under the new act is to ensure that the person interested are adequately compensated as early as possible when their property is acquired for a public purpose, and interpreting section 24(1) literally shall run counter to the object of the act 2013. The learned single judge erred in directing for preparation of award under the new act, referring to section 173A, 173B, and 13 of the act. It is contended that the above provision of the Act 1894 clearly indicate that where the amount deposited exceeds the compensation awarded by the collector under section 11, the excess is to be refunded within 3 months from the date of award. It is submitted that in some cases, 80% of the compensation can be higher or less than the award under section 11, a substantial part of the compensation having been paid under section 173A, which situation is not contemplated under the new act, taking into consideration the object of the act. The view taken by the learned single judge cannot be supported. Stop.